So welcome to Taming the Dragon, applying AI, predictive analytics, and NLP. Rogers and Nik Reed. Catherine and Nik, take it away.
Great. Well, thank you very much for having us. I'm not going to delay with any general introductions. We're just going to go right into the program because we have such a short time. And then we will try to take questions during the program, and if hopefully there might be a few minutes at the end. In any event, we'll be going through the slides very quickly, so we will be posting them afterwards so that you can access them if you didn't have a chance to focus on them during the program. Again, I'm Catherine Rogers with Arbitrator Intelligence, and Nik Reed with Knowable and co-founder of Ravel Law will be starting us off.
Great. Thanks, Catherine, and hi, everyone. I'm excited to be here today. So I'm coming to share some excitement and some kind of innovation that's happened around data and judges over the last few years. I'm going to talk a little bit about why it's exciting and what it does, a little bit about how we create it, and set the stage for Catherine to talk about why it is that all this cool stuff exists on a certain subset of judges, but we don't have it yet today in arbitration. But there's a way to get there, and it's very exciting, and that's what the primary focus of today's call is. So Catherine, if we can go to the first slide, the next slide, I guess.
There we go.
So yeah, as Catherine mentioned, I started a company called Ravel Law about 10 years ago out of Stanford Law School. We grew the company to the point where 30 of the top 100 AM law firms in the country were actively using us. And what we did is we used machine learning and natural language processing to analyze court documents to be able to tell attorneys trends in the way judges rule. That was kind of our banner product. We've since been acquired by LexisNexis, I should note, and we rebuilt the product. And the product now is in LexisNexis proper as a product called Context, and it's being used by pretty much every single law firm that is a customer of LexisNexis's, which is, as you can imagine, a really big population of attorneys using the product. What does it do? So imagine a world, and Catherine, if we go to the next slide, where you could answer certain kinds of questions. What if you knew the sentence your judge was most likely to cite when denying your motion? Or you could find the winning brief that matches an issue and topic already ruled on by your judge? Or what if you could find the holdings and citations that the judge is most likely to rely upon? Well, using machine learning and natural language processing, these are all questions we can actually already answer today. And I'll show you what that looks like on the next slide, Catherine. This is a snapshot of a judge and their motion history. And so on the left-hand side, you see a graph. And for different kinds of motions, we can tell you the grant and deny rates for a given judge. And then obviously with filtering, you can take that list and you can say, okay, well, if I'm appearing in front of Judge Coe and it's a security fraud issue and there's certain keywords or fact patterns, you can put in all those filters and then reduce the case and then see only those cases where Judge Coe ruled on a particular kind of motion for your fact pattern in your case. Similarly, you can even go a step further, and on the next slide, Catherine, we can actually show you the precedent that a judge relies on time and time again, every time they write a response to a particular kind of case. So what is the sentence that Judge Coe uses most often when denying or granting your motion type? And can you weave that in strategically to your argument because that's precedent that a judge relies on and follows and thinks is valid in your court? These are all tools that 100% exist today and that attorneys are using to plan better for going into court. A survey was done recently by the ABA, and 98% of attorneys that have done litigation in the last 3 years say they use judge analytics to better prepare before going into court for a given case. That's a tidal wave of change from 10 years ago when this didn't exist and it wasn't even an idea that most people had. And today, 98% of litigators see value in it and think they're using it in some way in the way they go to court. So how do we make this, and what's cool about the technology behind it? We're basically able to train computers today, and this is thanks to advances and natural language processing and cloud processing, decreasing the cost of running a ton of documents through an algorithm, and having the ability to kind of distribute work and bring it back together in a seamless way that allows you to teach a computer a little bit about language. So computers historically, have been very good. When you think about textual documents, the kind of main currency for attorneys, computers have been able to search and kind of organize and store documents. They haven't been able to really help us at all with interpretation or finding kind of needles in the haystacks and really dense, large groups of documents. With machine learning and natural language processing, we can start to teach a computer like what you see here on the right-hand side, which is take an unstructured document, a document that's just filled with a lot of words to a computer. And instead of just saying, can you match or find this word, we can start to teach it what this highlighting shows, which is we can say, oh, this kind of an entity is a lawyer name, and this other is a judge's name. And when it says a judge's name and then there's a verb conjugated in a certain way, that might be the holding that the judge is writing about. So, below here we say upheld in McConnell. So we can start to teach a computer to identify trends and patterns in language that enable us to slice and dice this data about a specific judge or case in really creative ways. I'm going to the next slide, Catherine. I actually want to be cognizant of time. Catherine, let's fast forward. Let's go forward 2 slides quickly, if we can. I don't know if it's just me, Catherine. I'm seeing the same slide.
Let's see.
It's forwarding for me.
It is forwarding for you?
It's moving for you?
Okay.
Yeah.
Okay.
So we're on the slide that says syntax and probabilistic. Okay.
Perfect. Yeah, so this is just one example of a trick. And when we talk about modeling language, there's a tool in natural language processing in which you can basically decompose a sentence and teach a computer that a verb conjugated in a certain way relates to other elements in the sentence, such that in this sentence, we know that when it says the court denies the motion to dismiss and motion to strike, 2 motions were denied by the judge and 1 was granted in the second part. So it's part of a whole bag of tricks that you need to use to actually structure language, legal language in an accurate way. But we have these tricks and tools available now such that we can structure large document sets. And what that allows you to do, and Catherine, let's just go to the last couple slides with, go forward 2 more, is it allows us to uncover really interesting trends in data. Yeah, and so going to the next slide, and I'll just run through these quickly. This is an example of the grant and deny rate across the top 10 motions in federal jurisdictions in the United States. And so what you can see here is, whether it's a motion for summary judgment or a motion for reconsideration, your chance of having your motion granted or denied can range from 50% to less than 20%. But let's kind of peel the onion back one more layer. So if we go to the next slide, Catherine. This is now looking across all district courts in the US just at motions to dismiss. And pending which court you appear in front of, you have from a 75% chance to a 40% chance of having a motion to dismiss granted. And if we go one step deeper, like on this next slide, this is actually just looking at one group of judges. So if you were to argue in front of Southern District of New York, depending on the judge you're arguing your motion in front of, you go from an over 70% chance of having that motion granted to a less than 40% chance. That's 30 points of difference on a motion to dismiss, something that can make or break your entire case, just depending on the judge that you're arguing in front of. And so, so think about that data, think about how powerful that is and how much it can affect your strategy. And unfortunately, in our court system, we don't really have the ability to pick our judges. They get assigned to us. We might be able to remove ourselves, but we don't get to pick them. Now, in the world of arbitration, it's a completely different scenario. And if we had this data, we could unlock a whole wealth of opportunity. And so, Catherine, maybe I'll pass it to you to talk about that.
Okay, so I'm going to take us from the world of litigation in the US courts to the world of international arbitration. And I think after watching, excuse me, after seeing Nik's presentation, you absolutely want all this analytics about arbitrators. The problem you have in international arbitration, and that's going to be the focus of my presentation, international as opposed to domestic, although there's potential here also for domestic. But what happens when all the information you need is secret? So as you may know, virtually all arbitral awards are maintained as secret. A few leak out here and there. In international arbitration, there are a few subcategories where they leak out pretty regularly, investment arbitration, or if they're sought to be recognized or enforced, but it's really quite hit or miss. And that leads to some really profound technological handicaps, right? So if the current technology that is used to research what might be called analytics, information about arbitrators, because it's all secret, is the telephone. Quite literally, and those of you who've been involved in picking an arbitrator know this. You send out an email, you ask, has anyone appeared before them? Because as the quote says, the key information about arbitrators and their past track record and rulings is really in different people's heads who've appeared before them in these otherwise confidential secret proceedings. And so the big question is, how do you create a database when all this information is secret? How do you get all this key information out of someone's head and into data analytics that can be used? That's essentially what Arbitrator Intelligence has done. Is we developed something called an Arbitrator Intelligence Questionnaire, which is a confidential online questionnaire. It's also anonymous, and it basically invites parties at the end of each case to provide key data from the case, from the arbitral award, which remains secret. We don't ask the parties' names. We don't even ask what jurisdiction they're from. But with that cover of confidentiality, they can provide us all sorts of details that are not confidential. They also provide feedback and evaluative information about the arbitrator's decision-making and perspectives on the case. We then take that information and we can do analytics. They are much different than what Nik is able to do with Ravel and the judicial analytics, because we're talking not about big data the way he has from the national courts, but instead much smaller data. Nevertheless, we are able to see some really significant trends in arbitrator decision-making, trends that should make you want to use analytics in picking your arbitrator. In addition, just like with judges, you need to know information about the arbitrator chosen by the other party and the chairperson. So one way to understand our process is we collect the data through something, our Arbitrator Intelligence Questionnaire. Excuse me, we then process the data, create these reports, which are used to select arbitrators. And then at the end of the case, the people who have used the reports, hopefully and through a very elaborate process I can comment on, give us data on the case they've just concluded. So look at that. That's not good. So the quote that I have doesn't show up, but it basically says we're trying to do for arbitration what Lex Machina, Ravel Law, and others have done for litigation, again on a much smaller scale. But here you can see what we are able to come up with. So Fernando Cantuarias is probably one of the top 2 leading arbitrators in Peru. And what we have for him, and this is again, you'll see the real difference in scale, is we have data on 19 arbitrations that was given to us by 25 different users. So we can accept more than one AIQ or feedback from more than one user in a particular case. But what here you would be key to see is if you are a respondent, you might be particularly interested in hiring Fernando Cantuarias, or appointing him, excuse me. But if you're a claimant, maybe a little more reluctant. We have 83% of respondent-affiliated AIQ responders, meaning people who submitted the AIQs, were representing or were parties who were on the responding side of the dispute. And 83% of them said that the award ended up being more favorable than they were expecting. Now, 24% of claimants recovered 0 damages. Again, these are really key data points, even though all the cases remain secret. I want to emphasize here that these are general commercial international cases. These are not domestic employment cases or domestic consumer cases where you might expect to see significant imbalance between win rates or perceived win rates between respondents and claimants. You would expect in commercial disputes to see a much more even breakdown. We have a number of other different types. This is the same information in a slightly different format. You can see most claimants who responded, who provided this data, found that the award was more or less as expected, which suggests he's a pretty good arbitrator. But again, the vast majority, 83% of responders who had represented on the respondent side found that it was disappointing. This is, to me, one of the most interesting charts in the whole report. We break down, based on the amount requested and the amount recovered, percentages of recovery for the claimants in this case. And then we cross-filter that with the perception among the responders, whether they won or lost. So everyone in this chart is a claimant, responding, someone who represented the claimant in the arbitration. Several of them recovered nothing, but interestingly enough, that's what they were expecting. A little bit startling. And then a decent percentage of them who got less than half of what they were requesting were also expecting that. I mean, we obviously see some who are disappointed in a small recovery rate, but what's really, to me, shocking is that it seems to me Cantuarius got it right. He gave 0 damages in a number of cases where claimants were actually expecting 0 damages. We also have, as those of you who are familiar with international arbitration, unlike national court judges, federal court judges, there is no federal rules of civil procedure. There are no federal rules of evidence. Instead, all of that, all of those rules, procedural rules, are replaced with arbitrator discretion. And you add to that discretion the fact that you have a very rich multicultural background where, for example, Americans, of course, are used to extensive document production. We call it discovery, and there are other tools as well. But in Germany, in France, in Brazil, the amount of document production in national court cases is roughly 0. If you know of a particular document, you can identify the author of the document and the date. You might be able to ask the court to request presentation by the other side of that document. But what happens when you get into an international arbitration is you have parties who are used to both traditions. And how is it decided which tradition prevails, or where in between those two traditions the document production is ordered? It's all in the discretion of the arbitrators, with some soft law sources. So one of the most important questions that people ask when they're trying to pick an arbitrator is this arbitrator going to give me the documents I need if I'm the claimant, or protect all my dirty documents if I'm the respondent? We ask questions about document production. We ask whether document production was requested. If so, was it granted? If it was requested, by whom was it requested? Claimant or respondent? Was it granted in whole or in part? If it was granted, what standard was used? And again, we look at the soft law sources that kind of give guidance to the arbitrators to see what parameters they used in granting document production. We then ask the sort of Goldilocks question. I don't have a blow up of it, but in this last chart on the bottom, I do have a blow up of this one, which is to show you the different standards that are used. These characterizations of standards come from a soft law source called the International Bar Association rules on the taking of evidence. We then, in the chart 7D, which is covered up, ask the sort of Goldilocks question. In your professional judgment, was the amount of document production granted too much, too little, or just about right for the dispute? And if I did pop up that, I think I can go back here, you can see actually the middle, just about right for the dispute. Cantuarius overwhelmingly, according to the people who responded, got the amount of document production right for the case. What's interesting is that's for both claimants and respondents. Okay, some thought he gave a little bit too much, but no one thought he denied them documents that were needed. Arbitrator Intelligence is much younger than Ravel Law, and we have not seen the success, obviously, of Ravel Law yet, but we have just launched our first reports for sale in the middle of July. We're in the process of building our inventory and also expanding and diversifying our products. Unlike judicial analytics, which I think are impacting a very established, structured public justice system, Arbitrator Intelligence is really seeking to, in many ways, reshape the market for international arbitrators and therefore impact a number of aspects of the fairness and legitimacy of international arbitration. One of the complaints about international arbitration, and it's not my joke, so I apologize, but is the pool of arbitrators, available arbitrators, are often characterized as pale, male, and stale, meaning that they tend to be the older white gentlemen from prominent North American and European law firms. As the whole field of international arbitration is expanding, both in terms of geography and size, there's a greater demand for more diversity. The ICA, which is an industry group, identified us in their elaborate report on the need for greater diversity in international arbitration as a force that is in fact promoting greater diversity. Why? Because now with our reports available, arbitrators who've only had their first few appointments can be known publicly. If you're a brilliant Brazilian woman arbitrator and you sat in 2 or 3 cases because you were appointed by an institution, congratulations. But how many people on the planet know about that? It's sort of like that question about if a tree falls in the woods but nobody's there to hear it, does it really make a sound, right? If you're a brilliant arbitrator but nobody knows that, you know, do you really have a reputation? We can fix that with our reports. In addition, for those of you who are aware of UNCITRAL, a UN body that is currently engaged in a massive contemplation of a massive reorganization or reform for the investment arbitration system, again, within the investment arbitration regime, one of the key problems they have is that the pool of arbitrators overall is too small, and they keep reappointing the same people. Why does that happen? It happens because you're only going to appoint an arbitrator who you know pretty well. Or who there's pretty much a lot of information available. And that, in other words, the lack of information about arbitrators and their track records constricts the ability to expand the pool of investment arbitrators. And as I mentioned earlier, investment awards tend to be publicly available. But where do you think new investment arbitrators come from? They come from the most prominent domestic commercial, large-scale commercial arbitration, or the most important international commercial cases. For example, like the 19 cases we showed you in the Cantuari's report. Cantuari's is actually sitting right now in 2 annulment panels for ICSID, but he's never appeared in an investment case, and there are no publicly available awards that are known about him, apart from some in domestic awards against the municipality of Lima, which are in Spanish. Our reports actually will help expand the pool because we allow people to make concrete evaluations about arbitrators who've not previously been investment arbitrators, but would make very good investment arbitrators in the future. So with that, I think in record speed, we finished our portion of the presentation, and I think we have, it seems like some questions. So I think we can open the floor for questions if anyone has any for either Nik or me. And if not, I'll take you back to our report and tell you some other nuances about it. If you have any questions, you can submit them through the question and answer. So Nik, did you want to go back to some of the slides that the one I love actually is the one that tells us that we didn't do sentence diagramming in 3rd grade for no good reason, that there was a purpose to that. I feel sort of vindicated by all that.
Yeah, it is fun to note that all of that hard work we did in grammar school is coming back to train advanced artificial intelligence. And that's about the level of complexity that we're at with computers. But once you can do that, you unlock a lot of opportunity. So this, yeah, so let's start here. So I think that the part that I kind of skipped over earlier was just to say that doing all this work is complicated. It's complicated for lots of reasons. And part of the benefit of the arbitration reports that Catherine and the team are generating is that they're creating all of the structured data from these surveys. When dealing with judicial analytics in the US court system, we don't have any structured data to start from. There's the docket and there's a certain amount of information you can get from there, but the docket doesn't actually have all the information that's contained in the individual rulings, which is why we were focused on the rulings written by the judges themselves. But a problem with the way we write is we can talk about the same kind of things lots of times. Into a computer, it just all seems like the right answer. So the example here is you could have one document that refers to a motion in lots of different ways. And if what we really want to do is teach a computer to just find when a certain kind of motion has been denied or granted, we need something like what you see in the upper left-hand corner, which is a sentence that's very clear on that. But we can mention a motion in lots of different ways. We can mention it procedurally, abstractly, or referencing a different case altogether. So one of the first things you have to do is kind of teach basic rhetoric structure to rhetorical structure to the computer so it can differentiate between these. And then the next step, if you go to the next slide, Catherine, which we talked about, is kind of the grammatical step, which is once you've taught the computer to identify the right sentences to focus on, teach the computer to understand what the sentence means if the sentence is complicated. And then the last kind of, there's actually 15 steps to this, I'm just showing 3. And yet another step is then teaching a computer to, throughout the case of a document, notice when we change the way we speak about the same thing. So in this example, we show how in the beginning of a document, you might say Dr. Zip filed a motion for summary judgment. In the next sentence or later on, all of a sudden Dr. Zip could become something like plaintiff. And so you say plaintiff's motion for summary judgment. A human really quickly, because we read with context and we retain information from as we're reading one given document, we're able to insert ourselves into the document enough to understand that Dr. Zip was the plaintiff in this case because Dr. Zip was the filer. And then later on, you can imagine that the case just says something like the motion is granted. The computer doesn't know what motion you're talking about, filed by whom. And so it's devoid of all that context. And so we use another tool called co-reference resolution, which basically tracks these parts of speech throughout the course of one given document and can kind of merge things such that the computer now understands that the type of motion is summary judgment, the plaintiff was Dr. Zip, and the outcome is that it's granted. And then that lets you do everything else. But Catherine, I think most of our crowd here is probably mostly excited about how any of this applies to arbitration data and where you're headed with that.
So what we do, one way to think of the Arbitrator Intelligence questionnaire is we basically crowdsource the coding of awards. We ask people who have the awards that we can't access to manually code them for us. And then we also ask them to provide information that's not in the award, factual information that's not in the award, as well as evaluative information, one of the most important pieces being whether they think they won or lost. But eventually, we would like to actually track a little bit more using natural language processing, artificial intelligence, some of the hard work that's already been done, excuse me, by Nik, to be able to what's called scrape arbitral awards. So we anticipate that in some time, there's a lot of talk right now. There's a sense of urgency about increasing transparency and access to information, transparency for the users of international arbitration, not necessarily, as is also discussed, for civil society external to arbitration. But how can the users get more information? There have been all sorts of proposals about posting, making publicly available redacted awards. That's very labor intensive, and actually the payoff is expensive. There might be artificial intelligence, opportunities for that in the future, but as it turns out, it also requires consent from the parties. And the reality is parties are not comfortable, or small percentages of them are comfortable seeing the award actually out there, even if crucial information is being redacted. A lot less concern comes up if you're just essentially scraping the essential data from the award. So we anticipate, and we have a number of relationships with arbitral institutions around the world, that at some point soon, they're going to agree, if nothing else through user pressure, to allow third parties to come in and scrape their awards and essentially accumulate. And that's when we start going from this kind of tiny, manually gathered data to nowhere near the scope of data that Nik has, but something closer to big data. So with that, I think we are getting the sign that we're close to closing. We'll be posting our slides online. I don't think that there's an email or a website for Ravel Law anymore, but it's available on Lexis. And Arbitrator Intelligence, you can reach us at arbitratororintelligence.com. Thanks so much for your attention and enjoy the rest of the program.